Hello, everybody. It's Walter, your favorite historian, educator, professor, and social studies extraordinaire, here today to discuss with you a very important and powerful topic that affects us all. Donald Trump is removed from the Colorado primary ballot. On the 19th of December 2023, in the case of Anderson versus Griswold, the Supreme Court of Colorado ruled in a 4-3 decision that Donald Trump, former president of the United States and Republican candidate for president in the 2024 presidential election, was ineligible to be listed on the state's primary ballot scheduled for March the 5th, 2024. The reason was clear. He was in violation of Section 3 of the 14th Amendment to the United States Constitution, which bars anyone engaged in or aiding rebellion against the United States from holding elected federal office. Given the court's venturing into uncharted legal territory and the certainty of U.S. Supreme Court review of the decision, the Colorado Supreme Court stayed its decision until March the 4th, the day before the state's primary, or indefinitely, pending a decision from the United States Supreme Court. The Colorado justices, all appointed by Democratic governors, understood the legal gravity of their ruling, and in their opinion, they wrote that, quote, "We do not reach these conclusions lightly. We are mindful of the magnitude and weight of the decision now before us. We are likewise mindful of our solemn duty to apply the law without fear or favor and without being swayed by public reaction to the decisions that the law mandates we reach. We are also cognizant that we travel in uncharted territory," end quote. Now, for those who think that this case was filed by vengeful Democrats and left-wingers, you are entirely wrong. This case began in the Colorado courts, and it was filed by Republican and unaffiliated voters, ladies and gentlemen, not Democrats. All right? And that is also listed in the court's opinion at the very beginning, as a matter of fact, and it states that more than 3 months ago, a group of Colorado electors eligible to vote in the Republican presidential primary, both registered Republican and unaffiliated voters, the electors, filed a lengthy petition in the district court for the city and county of Denver, all right, asking the court to rule that former President Donald J. Trump may not appear on the Colorado Republican presidential primary ballot. Facts, not opinions, folks. So needless to say, Trump's legal team and Republicans as a whole were infuriated by the court's decision, okay, chastising the justices of the Supreme Court of Colorado as political hacks, judicial activists that were violating and flouting the rule of law and hell-bent on destroying Trump's candidacy in the 2024 presidential election, in spite of the fact that the case was filed by Republicans and independents, not Democrats, but whatever, I guess. These Republicans are confident that the Supreme Court will reverse the Supreme Court of Colorado, basing their claim on the fact that technically the section doesn't bar someone from holding the presidency, but does bar them from holding other federal offices beneath the presidency, members of Congress and so forth and so on. All right, that's their opinion. All right. And also arguing that the Supreme Court of Colorado was politically motivated in its decision. All right, even though they based their decision clearly on law and not opinion. Many also argue that because Trump has not been convicted of anything as of yet, Section 3 does not apply. Okay, that too is their opinion. Lastly, former House Speaker Newt Gingrich, who nobody, in my opinion, holds as the prominent voice of reason for anything, has come up with a bogus proposition that Section 3 does not apply to the present day at all, but only it applied to targeted offenders from the Civil War era 150 plus years ago. All right. Now, therefore, in Gingrich's mind, Section 3 is no longer an operative part of the Constitution. So you'd have to have been an offender 150, 160 years ago for this section to apply to you, in his opinion. Thankfully, he is not in charge of anything or the voice of reason for anything for that matter. So my take on it is quite simple and to the point. You know I don't cut cards. The Supreme Court of Colorado, ladies and gentlemen, was absolutely legally correct in its decision. All right. Donald Trump instigated the treacherous attack on our government on January 6, 2021. It is beyond clear. All right. And interestingly enough, many Republicans aren't denying or affirming that fact. Second, Section 3 of the 14th Amendment in no way requires a conviction of any kind to be disqualified from holding federal office. So that argument falls flat on its face. They're adding to the language of the Constitution something that the Constitution itself doesn't even require. Interestingly enough, Republicans usually attack liberals for doing that. It's known as judicial activism, all right? Section 3 does not require a conviction to be found to be in violation of it, all right? Number 3, Section 3 does not deliberately include the presidency in his language. Given the context of the amendment and understanding what we know about the Civil War and understanding the intent to punish anyone engaged in or aiding the rebellion, any rebellion against the United States, it's hard to imagine how the framers of that amendment, who included John Bingham, Thaddeus Stevens, Jacob Howard, and many others, how they would have intended to exclude such persons from holding office in the House of Representatives or the Senate or other offices, but not the presidency, the highest office in the land. That makes no sense. And for them to even make that argument is completely idiotic, to say the very least. And fourth, to Newt Gingrich, if Section 3 was exclusively limited to Civil War offenders, then the Constitution would specifically say such a thing or deliberately close its language to that, all right? Neither of which it does, all right? Unless otherwise stated, Section 3 applies just as much in the present context as it applied in July of 1868 when the 14th Amendment to the Constitution went into effect. All right? So these Republican arguments, ladies and gentlemen, against Section 3 being applicable to Donald Trump are, as from what I've given to you flat out, based more on opinion and rhetoric than actual fact or history. Clearly, none of these people who understand the context of Section 3 of the 14th Amendment understand what it was designed for, nor do they understand how it operates. And since the Supreme Court of the United States has never passed judgment on the reach and effect of Section 3 of the 14th Amendment, no matter how they rule, this is going to be interesting. If the Supreme Court affirms the Supreme Court of Colorado, then that is going to almost certainly imperil Donald Trump's ability to be a candidate in the 2024 presidential election. If the United States Supreme Court overturns the Supreme Court of Colorado, then that is going to set a very troublesome precedent, in my opinion, that will indeed leave Section 3 almost a meaningless dead letter part of the Constitution. If being a party to aiding and inciting a rebellion against our national government, of which he clearly was a part of, if that is not a disqualifier from holding the presidency, then for heaven's sake, what is? I think the Supreme Court needs to understand the very real gravity of their decision, no matter how they rule, and to think very carefully and cautiously about how they rule for the sake of American democracy and for the sake of our constitutional system and structure. The facts present themselves clearly, folks, that American democracy, sadly at this point now, hangs in the hands of 9 unelected, life-tenured Supreme Court justices who are not exactly in the highest esteem by the American public right now. The Supreme Court does not make its decisions in a vacuum, and the cases that come to the court do not just originate out of whole cloth. They come from often years' worth of litigation, and the court must set the tone of finality on these matters. And all I can say is I certainly hope that the court understands the ultimate effects on American constitutional democracy, no matter how they rule. All right? So I thank you so much for listening to my take on Donald Trump being excluded from the 2024 Colorado presidential primary ballot. Now, some people have also said, what about write-ins? Well, the Supreme Court of Colorado has ruled that the Secretary of State cannot accept those if he's disqualified. So that's that. Any questions or controversies, leave them down below. I'll be happy to answer them. Take care of yourself. Stay safe out there. Professor Shelton, out.